Court Feed.
And this is cause number 22-39304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. That probation was for a 3-year deferred probation.
Okay, let's pause here. Abandoning or endangering a child is a state jail felony, which means she dodged actual prison time by getting deferred probation.
Right out of the gate, this case feels like a collision between addiction, mental health, and accountability. One side sees repeated probation violations. The other sees a woman spiraling after a major medication change. And the judge? She's stuck deciding whether this is someone gaming the system or someone genuinely falling apart. Pay attention, because this hearing is about to turn into a courtroom tug-of-war between punishment and treatment.
But now the judge is reviewing a list of probation violations, curfew, drinking, even trying to find drugs. That's a legal red flag parade. Do you think she deserves another chance? Or is this the point where patience runs out?
October 17th of 2022. Has that been extended? Okay. So obviously, we'll see what we do today, but if there's going to be SAFPF, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request SAFPF, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th and March the 20th, and shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately...
Here's where things get complicated. The defense is arguing this all spiraled because of a medication switch from Seroquel to Prozac. That's not just a detail. Medication changes can massively affect behavior and impulse control. So the question becomes, is this a criminal relapse or a medical crisis that got misinterpreted as one?
Started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues.
This is the moment the defense tries to flip the entire narrative. Instead of repeat probation violator, they're painting Michelle as someone caught in a mental health tailspin triggered by medication changes. And strategically, it's smart, because judges are far more willing to support treatment when there's documented medical evidence instead of just excuses. But here's the problem. The court has heard promises before, and patience gets thinner every single time.
What I'm asking the court to do is not to exactly undo the SAFPF. What I'm asking the court to do is hold the SAFPF in abeyance, give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay, whether it be 14 days, whether it be 30 days. I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the SAFP in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if SAFP is still in her actual best interest at this point. We understand that SAFP is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this, and she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
Do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if it feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, the main hesitation on our part is that she agreed to SAFP and now wants to do things on her terms. I think SAFP is where she needs to be based on the relapse and violations she had. And I want to bring the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go.
And there it is. The judge draws the line. She's ordering special needs SAF, a program that combines addiction recovery and mental health treatment. That's actually rare and pretty compassionate. Plus, she tacks on 2 more years of probation to make sure it sticks. Fair call, or too harsh for someone struggling with meds and mental health.
Went to a private inpatient program in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Ruiz can testify to that, though, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part
You were a
of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. SAFP is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in SAFP if she has the right medication and she is of the right frame of mind.
The special needs SAFP facility, do they adjust medications and things like that?
Yes,
yeah. I think based on what I know now from the beginning that we ordered or agreed or whatever happened with ISF and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special.
The judge didn't give Michelle exactly what she wanted, but she also didn't slam the prison door shut. Instead, she chose the middle ground, stricter supervision with specialized mental health treatment. That's a huge distinction. In a lot of courtrooms, repeated violations like this end with handcuffs and a transport van. But this judge clearly believes there's still a chance to stabilize her before the system gives up completely. The real question is, was this a life-changing second chance or just one final warning before everything collapses?
Need safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there. And I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it, however. It's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare.